who have joined us this morning. We are very, very grateful for your time. So without taking much of your time, considering that we've time into what the stipulated time, we'll take you straight into giving an overview of Hatto Foundation, the institution that is putting this webinar together. So, for purposes of brief background, we are giving a glance of what Hatto Foundation is. Hatto is an environment NGO, international environment NGO, that is actually registered here in Ghana and in Canada since 2001 and 2023, respectively. So in Ghana, we began work officially, actually in 1999, but we officially got registered in 2001, and in Canada, we did so in 2023. Currently, registration is ongoing in other African countries, like you can see there in Kenya and other parts of the African countries. So at heart of, since it's an environment NGO, we subscribe to some international multilateral agreements that we are admitted observers to these agreements, and you can see them there. You have the UNFCCC, the UN Convention on Climate Change. We have the Convention on Biological Diversity. We have the Convention to Combat Drought and Desertification, that is UNCCD. And then we are also affiliated to the UN Environment, and currently we are also in close working relationship with the UN ECOSOC. Currently, we've also gained an admission observer status to the Minamata Convention on Mercury. So we do some activities in the areas of chemistry. For that actually are given the mandate to make resources available to these international conventions that we subscribe to or we are admitted observers to. We have the Green Climate Fund, we have the JEF for the Global Environment Facility that Hatov is also a member to this multilateral financial institutions. So we are very much well positioned as an institution to kind of bring you up to speed information from these multilateral processes that we subscribed to. So on my right-hand side, you see some partners, key partners we've worked with. Some are partners that we work with, others are clients that we've worked for, and others are sponsors that actually provide resources for the work that we do. So we see the Environmental Protection Authority, you see the DOTSE from University of Ghana, you see African Development Bank, you see Forestry Commission, you see Energy Commission, you see Ministry of Environment, Science and Technology, Ministry of Foreign Affairs, Ministry of Finance, and a whole lot of institutions that we work with. So based on the position of Hatto Foundation as an environment NGO and the work we do, we work with all these institutions and in the country and then also beyond. So at Hatto, our main focus is to protect or promote sustainable development and human well-being through the four main pillars you have on the screen. We do this through capacity building and training like we are doing today, trying to give information on the BBNJ, which falls within the multilateral environmental agreements. We also are into programs and projects management. So you see that we have done some work along the beach with Australian High Commission and then with our interns from abroad and internally. We also into policy advocacy and knowledge exchange. What you see there is one of the policy dialogue sections held in Sharm el-Sheikh at COP, the UNFCCC COP, where we try to deal with or discuss issues on finance, how to get climate finance accessible to developing countries, including Ghana. And we also provide technical assistance. In this case, we try to help institutions to be compliant with global environmental governance. What are the institutional provisions, policies, guidelines, or strategies and plans that one needs to put in place to be able to either attract international resources or be aligned with global obligations that Ghana has signed itself to. So our main focus areas, you can see we are dealing climate change, biodiversity, energy, food and agriculture, climate finance, chemicals and waste, blue economy, where the issue of the BBNJ actually falls. Quick one. I mentioned that we are admitted observer to the UN Convention on Biological Diversity. So we just want to concentrate on the biological diversity because of the fact that today's discussion is on the BBNJ, that is Biodiversity Beyond National Jurisdiction, and it falls directly within the remit of the UN Convention on Biological Diversity. So I'll give you just a brief of how HATOF has engaged nationally in this process. We have done that, as you can see, way in 2016, what we started doing. Even before 2016, in 2002, we began working with the Ministry of Environment to develop our first national biodiversity strategy and action plan. We also helped to, get the updated document in 2016, and then in 2024, the biodiversity action plan is also updated. As we speak currently, the fourth action plan is still under development. We are almost done, and HATOF Foundation has provided an extensive contribution to the work because of our role within the global space, and then also our project implementation at the local level. We bring this knowledge from the local level to the policy process at both national and then the global level. 2016, we did some work for the ministry, helped them to develop, assess the funding needs of the country as far as biodiversity is concerned. We also helped them to develop what we call the natural capital accounting capacity building under the Convention on Biological Diversity. It was the first score that HATOF actually put together for the ministry, and then thankfully resources were made available to the ministry to build capacity nationally between 2017 and 2018. And then we also developed the National Biodiversity Policy Draft, which is still in the draft stage. We are hoping and looking forward to how we can transition this into policy moving forward. And then also in 2017, HATOF joined the global community, the the Convention on Biological Diversity, to establish a youth wing, that is the Global Biodiversity Network. So that youth wing, we supported the convention to establish. We are hosting the national node in Ghana currently. That is what we call the Ghana Youth Biodiversity Network. So the secretariat of this young chapter that is affiliated to the Convention on Biological Diversity is housed in HATOF. And then also we have done some work with the UNEP and the convention itself to transition from the ACI target to the Kunming-Montreal Biodiversity Framework. So just like we have the convention, we need to have protocols that are going to be used to implement the convention. So we move from ACI target, and then now we have what we call the Kunming Biodiversity Framework. So HATOF was very instrumental in this process to getting the framework designed and adopted in time. And lastly, on our engagement regarding biodiversity at the global level, I bring you to some of the COPs that HATOF has attended. You see our Chief Executive Officer and his engagement in all these roles. The COP happens every 2 years. So for every 2 years, HATOF participates as much as we can to bring national interest into the global discussion. So I wouldn't take you deeper into this, but you can see on the screen, the latest one that we attended was in 2014 in Colombia, where we had series 2016. The COP 16 in 2024 in Colombia. Yeah. So that is the latest COP that we have. As we speak, the COP is going to have its 17th meeting in Armenia in November, either November or December this year. I think October, November, within October this year. So we're looking forward to having some of you join us, going to discuss how we can actually champion the issue of biodiversity. And I can tell you for a fact that this discussion we are going to have today is extensively discussed at the biodiversity convention level or the conference level. The issue of digital information sequencing, the issue of biodiversity beyond national jurisdiction, how do we look at benefit sharing and all of that. That discussion is extensively discussed during the COP. So when the next presenter comes, he will take us through how these discussions emanate from the COP and then how it transitions to the national level. So I think I bring my discussion or presentation on HATOF to a close. Thank you very much for your time. I'll hand over to Ms. Yemeti.
Yeah, hello, good morning to everybody, and good afternoon, wh- wherever you find yourself on the globe. It's always an honor to have wonderful people like you listen to the little contribution that we are making to save the planet. Yeah, so just as we informed, we are looking at ocean governance before the BBNJ agreement. Then we'll be looking at what do we actually mean or meant when we say areas beyond national jurisdiction. Then, of course, we want to see how the BBNJ agreement was born, the pillars that support the implementation, and what implementation or what implications will it have for developing countries like Ghana and other countries within the continent of Africa or the global south. Then try to look at some opportunities that can be derived when the agreement is effectively and efficiently implemented. And what will Ghana benefit? Because I'm a Ghanaian, so I have to look at the interest of Ghana with this. Therefore, uh, the first question that I want to ask and the audience is the ocean governance before the BBNJ. What has happened, or what has happened? So we cannot pretend to say this is the first time we are going to have a discussion on ocean governance. So we'll look at what transpired before we are at where we are today. We're looking at some early ocean governance issues, which, in other words, I refer to some of them as the early intellectual foundation of the law of the sea. Uh, if you see on the screen, you find two gentlemen whose photos I displayed over there. They are academics or intellectuals. Both of them are lawyers. One is a British. I think one is is from Spain or Italian. The Hugo in 1609, you see how long we have come, postulates that the doctrine of postulate that sea is free for every nation, that all coastal states should consider the sea or the ocean to them, where they have a minimal control. Then the other gentleman, John Selden, opposed his views and indicate that no, the ocean cannot be for every nation or coastal states, and that there should be what he also described as a closed sea, so that you can have, as a coastal state, you can have authority to a certain limit, but the rest you are not, it is for everybody. So that argument lingered on until the 18th century, where the issue of the territorial sea had become very contentious, for which a decision need to be made. Why do I say so? Rising interest in offshore oil exploration, fisheries, security issues, birthed the Trauma Declaration. This Mr. Trauma is the head of state of the United States of America and other nations that believe that because of their technological power, they can just go into the sea and harvest anything that theirs or appropriate. Kind of thinking triggers the global expansion of maritime or territorial sea claims. Each country trying to claim some portion of the sea for itself. So, as a result of that, in 1930, the League of Nations convened a meeting in The Hague called the Hague Conference, which was a first attempt to have an agreement, but it failed because of the geopolitical interests. Then in 1958, the United Nations General Assembly had the first conference on the law of the sea, which is referred to as UNCLOS 1. And in that meeting, 4 separate conventions were proposed, or 4 acts. One dealing with the territorial sea, other one dealing with the high sea, then the next one dealing with the continental shelf, and then the last one dealing with fisheries. Now, the question then is, this UNCLOS 1, what has it achieved? The achievement that came out of the UNCLOS 1 clarified some legal privileges or principles relating to navigation, fishing rights, and then continental shelf, as I indicated earlier. However, the UNCLOS 1 failed to resolve crucial issues, particularly the breadth of the territorial sea and the legal status of seabed resources. So, in 1960, the second conference on the law of the sea also attempted to address the unresolved issues of the first conference, but unfortunately, the negotiation ended without consensus. What did it produce? It highlighted tension or division among maritime powers and coastal states. The issue was that they were split between the issue of the distance, what territorial areas that each coastal state should control. So the division was between whether should we have 6 nautical miles or we should have 12 nautical miles. So, with all these things happening, there was a gentleman, these Malta diplomats, I don't know why they have so much knowledge. The turning point came for the ocean governance. Then in 1967, this Arvid Pardo, who is a seasoned diplomat from Malta, introduced the idea that deep sea bed should be called or should be referred to as common heritage for mankind. His speech to the UN General Assembly on November 1st, 1967, actually provided the platform for superpower rivalry extended to the oceans, and said the only way to avoid that is to ensure that his principle is upheld, and that there is the need for an international regime over the seabed and ocean floor beyond a clearly defined national jurisdiction. So, hence, the third conference on the law of the sea then clearly came out with one, they agree on how long the territorial sea should be, which is the 12 nautical miles. Then the balance between coastal rights and the high sea freedom. Then the framework that will govern the oceans. Then, of course, how long the exclusive economic zone, which the convention agreed on 200 nautical miles for each coastal state. It is important for us to know that this milestone were achieved 9 years later with the adoption of the UNCLOS in 1992 Mountain Bay in Jamaica. Now, the convention then came into force on November 1994 after Guyana became the 60th state to do signature. I mean, you will understand that in multilateral environmental agreements under international law, there is a principle that a certain number of states will have to do the signature in order for the ratification in order for the treaty or the convention or the protocol to come into effect. So under UNCLOS, they were looking at from one country to the 60th country. So once that is achieved, then the convention will come into force. Now, this UNCLOS 3 have some institutional arrangement to deal with the issues that the governance of the ocean is looking at. So one key institution, or two of them, is the first one is the International Seabed Authority, which is also having a headquarters in Jamaica, that is probably the responsibility of looking at deep seabed mining. Then we have the International Tribunal for the Law of the Sea that is established to settle disputes. And then the third one, which deals with the continental shelf limits, is the CLCS. If you remember, I think 2017, there was an issue between Ghana and Cote d'Ivoire. So that dispute between Ghana and Cote d'Ivoire was settled under the authority of the International Tribunal for the Law of the Sea, ICLOS. Now, the UNCLOS, as I've already explained, establish the clear maritime zones, which deals with the territorial sea, the contiguous zone, the exclusive economic zone, which is the 200 nautical miles, the continental shelf, and the high sea, and the area which I have highlighted over there. Very soon we'll look at, when they say the area, what we are looking at. Then, in the issues of the use of the oceans, the convention allows for navigation, for fisheries, marine scientific research, and then the seabed mining. Of course, when activities are being conducted on land, we do environmental impact assessment. So in the same vein, when activities are conducted on sea, environmental obligations are placed on states or institutions that want to harvest the resources that we find within the ocean environment. That is provided under the Part 7 of the Convention, which talks about protection and preservation of the marine environment. Then, of course, the dispute settlement, which is also a characteristic of almost all the multilateral environmental agreement, because it is believed that whatever it is, there is going to be dispute. So there should be a mechanism as to how it should be addressed. Then our country, or Ghana, did a signature and ratification to acquire the legal status first, 10 December 1982, to do with the convention, and then did the ratification on 7th of June in 1983. Now, in terms of institutional arrangement to deal with the UNCLOS in Ghana, we have the Ministry of Foreign Affairs. There's a department that deals with UNCLOS. Then we have Ministry of Fisheries and Aquaculture Development. Then we have the Ghana Maritime Authority. Then we have the Environmental Protection Authority. We have the Ghana Navy, and then the Attorney General Department. Let's also indicate that because we are dealing with boundaries in the government of Ghana has also established an institution called Ghana Boundary Commission under Ministry of Lands and Natural Resources. They provide technical information for Ghana in terms of how we deal with our neighbors and what our territorial jurisdiction is all about. Now, just as I indicated, that the UNCLOS provides for a number of key issues, and one of them is area. So here we wanted to look at what are the areas beyond which there was or there is a need for a legal agreement to protect. So if you look at the map here, you will see that every country with a coastline has a territory in the ocean that belongs to that country, called exclusive economic zone. That is the 200 nautical miles. Now, beyond this exclusive zone lies the area beyond national jurisdiction, which are not covered by, which are not owned by any nation. So everybody covers about 64% of the oceans and include ecosystems and species that contain genetic materials. Remember when the previous presenter was talking about Hartog's engagement, she did mention of digital sequencing information. So that is what we are looking at over here. And this brings many benefits to our planet and to humans. Now, if you look at the map, you realize that yes, we have the dry land, we have Tema, we have Accra, we have Takoradi. Ghana has a coastline of 550 kilometers. So the measurement which was agreed under UNCLOS 3, where we have the 12 nautical miles that covers your territorial sea, where you have a sovereignty, you have the right, nobody can come and deal with you over there. Everything over there belongs to you. Then the next one, which is the 24 nautical miles, that is the contiguous zone. Then you have your 100 nautical miles, which is your exclusive economic zone. Then beyond that is referred to as the area or the high sea. So that is if we are dealing with Ghana. Right. So we then want to look at the maritime zones and its limitation. Just as I indicated, you see that the map here I indicated a baseline, mean low water mark, where you have your internal water. So from the baseline and point A, that is referred to as your 12 nautical miles, which is territorial waters. Baseline to point B, that is 4 nautical miles, which is your contiguous zone. What happens there is that, yes, it is within your right though, but you don't have exclusive right. You can allow others to do navigation and pass there, but you have the authority that if you suspect that any oncoming vessels is carrying something that you think is dangerous to your national security, you have the right to intercept it and then try to interrogate or investigate why, what are they carrying and that kind of thing. Then, of course, the baseline and the end of point C, which is the exclusive economic zone, belongs to you, that you can do all the economic activities, especially when you are looking at the seabed, where we have some critical minerals. Then beyond that sea, we have the continental shelf, which is up to 350 nautical miles. Now, the ABNJ has two main groups. That is the high sea, where we have the water column. I think we'll find it in the next slide. Beyond exclusive economic zone, and the area that is the seabed and ocean floor beyond. These constitute the 2/3 of the global ocean. Very good. So now you see that the plain area, which looks like a clay, that is the ocean floor. Then the blue, the deep blue, and the light blue, and what have you, that is the water, or that is the sea. So between you have the from 0 to 12, which is your territorial sea. From there you have the 24 nautical mile, which is the contiguous zone. Then from the 0 to 200, which is our exclusive economic zone. Then the outer continental shelf, which the law allows you to go beyond the 200 nautical miles to 350. Now, where you see the broken pink line, the area, which is where the seabed over there belongs to nobody. That one is no man's land. So whatever is there belongs to everybody, right? Then you see the top, you have the high seas, that's the water column. Now, if you look at the pink, you see that areas beyond national jurisdiction starts from where the broken line ends up to, if you look at the high sea, the top. So that is the areas belong national jurisdiction, which belongs to nobody and is managed by International Seabed Authority based in Montego Bay, Jamaica. Even where a state has an outer continental shelf, you see that the seabed is equal to or is under national jurisdiction, as I have illustrated over there. The water column above it, that is the high sea. So we have the area below national jurisdiction. Then the high sea starts where the exclusive economic. I'm just explaining what I have just indicated. Now, having said all of these things under UNCLOS, the question then is this: UNCLOS, the gap that was identified is that UNCLOS did not provide a comprehensive system for protecting biodiversity in the area beyond national jurisdiction. The question then is, so who governed the area beyond condition within UNCLOS? Governance was distributed across different organizations depending on activity that need to be undertaken. So as I indicated earlier on, if you take activity like fish, you have the regional organization, RFMOs, for example, the International Commission for the Conservation of Atlantic Tuna and the Commission for the Conservation of Antarctic Marine Living Resources. Recently, if you hear some countries wanted to go and claim the Greenland, there is a portion of the earth that is designated the Antarctic region. That region is solely reserved for scientific exploration. But now states with technology and military power wanted to go and start putting their. Then the other issue activity talking about is shipping. Shipping is regulated by International Maritime Organization, and the seabed, as I indicated earlier, is being handled by International Seabed Authority. Then, of course, the territorial claims by the Commission on the Limits of Continental Shelves. So, this, what I've described above, means that no institution has the responsibility for the overall protection of biodiversity in the area beyond national jurisdiction. As a result, environmental impact across sectors were not the same ecosystem without an integrated assessment. And also, conservation measures were extremely limited. Why should I say so? For example, a mining operation regulated by East International Seabed Authority might affect fishing stocks managed by RFMOs, yet neither institution was required to coordinate environmental assessment. So you see the gap between the institutions as far as biodiversity protection or conservation is concerned. Let me quickly add that the coming into force of the Convention on Biological Diversity in 1992 is a precursor for all of these things that I am talking about, because the CBD was dealing largely with biodiversity on land and a small fraction of marine and coastal zones or coastal ecosystem, leaving the huge high sea for under no protection or under no legal regime. Therefore, when we are talking about biodiversity in the area beyond national jurisdiction, what kind of biodiversity are we looking at? So these are the issues that we have left out in the UNCLOS implementation. One, marine species and ecosystem. A wide range of living organisms and ecosystems that exist in the open space and the deep sea. Example, we have marine mammals such as whales and dolphins. They are there. There's no protection for it. Then we have the marine genetic resources. These genetic resources, materials from marine organisms that may have scientific, pharmaceutical, and industrial value. They are also there. Example is microorganisms used in biotechnology and medicine. Ecologically important ocean features that support biodiversity are as follows. If you see the diagram over there, there is this sea moss underwater, underwater mountain that hosts rich ecosystems. Then we have the hydrothermal vents. These are the first ecosystem on Earth found not to use the sun as an original source of sulfur-rich energy. So you see how valuable the biodiversity in the area is. Then the last but not the least is the spongy reefs and fields, which provides habitat and refuge for species, including those important for human consumption. For example, the redfish and the cod. Yeah, so these are the biodiversities that the legal regime of the UNCLOS failed to cover or protect. Then the question there would be, why should we then care for the biodiversity in the area? Quickly, the key things are they regulate ocean temperatures, global temperatures, sorry. They form 2/3 of the fish stock that we face beyond our sustainable limits. So overfishing in the area disrupts the marine communities and affects the ability of commercially important species to replenish their stock. For example, billions of us depend on the ocean for food and income. Last but not least are the species found in the deep sea covers are the sources of medicine and supplements to fight cancer, arthritis, heart diseases, and Alzheimer's. So you see why there's the need for a legally binding instrument to protect this for our own survival. Then the almighty BBNJ agreement. So I want to look at the history and the structure of the treaty. So as I already alluded to the fact that there are some historical foundations. If you look at the treaty, in June 2015, the United Nations General Assembly established a preparatory committee on BBNJ, and that committee then was empowered or was given a mandate to convene an intergovernmental conference to draft an initial text. And in April 2018, the IGC had an initial organizational meeting. Then in September 2018, they had the first session. Then in March to April 2019, they had a second session to look at the draft. Then in August 2019, they had a third session. Then in March 2022, they had a fourth session, which was, they were to have the fourth session, but because of the advent of the COVID, that meeting was postponed. They had a fifth session instead of March, rather in August 2022. Then in February to March 2023, they have a resumed session. Then in June 2023, they finalized the text and adopted it in a meeting with the objective to conserve or the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction. Article 2 actually speaks to that. It covers the ocean areas outside each country's coastal states exclusive economic zone. So that is the history and the trajectory of the negotiation of the BBNJ. Last as I indicated, if you look at the text, which is very important for each participating country, part 1 look at the general provisions from Article 1 to 8. Then the part 2 look at marine genetic resources, including questions of beneficiary. Well, those were the key issues ranging between developed and developing countries during the implementation of UNCLOS 1, 2, and 3. Then part 3 look at measures such as area-based management tools, including marine protected areas. That is handled between Article 17 and 26. Then the part 4 look at environmental impact assessment, but Article 27 to 39 deal with that. Then part 5 look at capacity building and transfer of marine technology, Article 40 to 46. Then the part 6, institutional arrangement. So there you are going to have the COP, the scientific body, and the rest of the things that is going to happen. That's where you see then the financial resources and the mechanisms that will provide money for the implementation. Then the settlement of dispute, of course, like I indicated. Then the part 10 look at the non-parties to the agreement. Yes, of course, if you are not a coastal state, maybe you are not obliged to ratify or sign. Then the part 11 look at the good faith and the abuse of rights. Then the part 12 look at the final provisions. Then we have 2 annexes. The annex 1 looking at indicative criteria for identification of the areas. Then the annex 2 look at types of capacity building and the type of marine technology that is available. Now, the key issues that the agreement is resting on are 4. 1, the area-based management tools, call it the ABMTS, then the marine genetic resources, then the environmental impact assessment, which is very, very critical, then capacity building, and the transfer of marine technology. So what are the key provisions? If you take the area-based management tools, the BBNJ establishes a collaborative cross-sectorial approach to setting up area-based management tools, including marine protected areas in the high sea region. The countries made a provision for proposal for the NPA or the MBMTS, which should look at an exclusive system for consultation. There should be an inclusive system for consultation, a robust scientific assessment to inform decision making. Yeah, so that if you want to set up either the ABMTS or the NPA, these are the things that you have to do. And in the previous countries were doing some of these things bilaterally, but now there's a global framework that is governing or that's guiding everybody to obey all the things that are listed over here. So provision to establish ABTMs, including NPAs, then ability to adapt measures where there is no existing body with competence authority to do so, then ability to make recommendations on actions on measures where measures are within competence of existing body. The parties may opt out of measures adopted by the COP on limited number of issues. I mean, for those of us who have been involved in other multilateral environmental agreement negotiations, all of this that is not new. It's just to reaffirm that, yes, just as we are implementing the Paris Agreement to address the issues on the Framework Convention on Climate Change, BBNJ is doing the same thing to implement UNCLOS. Now, when it comes to environmental impact assessments, the BBNJ establishes an EIA process for activities on high seas. The EIAs are a management tool to evaluate the likelihood of any environmental impact on proposed activity or actions that will take place, and taking into consideration the link between socioeconomic, cultural, and human health as impacts, both positive and negative. So what those articles that I've spoken about, provisions for comprehensive and rigorous assessment of activities on the high sea, provisions to harmonize BBNJ with ENA, EIAs conducted under other international bodies, the state decision making on activities on the high seas under jurisdiction or control following an EIA. Let me indicate here that under UNCLOS, individual countries conduct the EIA. Like for example, Ghana Environmental Protection Authority has the mandate to issue permit and what have you. So under UNCLOS, Ghana need not to talk to anybody. We don't have to go and do that. But under BBNJ, there is a global framework which has been established, which Ghana cannot unilaterally say that, okay, I wanted to go into the high sea to go and look for hydrocarbons and what have you. So I am going to do the EIA as I deem fit. No, that is no more the case. If you come to capacity building and transfer of marine technology, the BBNJ outlined the process by which parties, those who are signatories and who have done the ratification, within their capabilities, must ensure capacity building and cooperate to achieve the transfer of marine technology to developing states parties to achieve BBNJ objectives. How is that going to be done? As science and technology advance, human activities in the area beyond national grid have revealed previously unknown knowledge about ecosystem and their potential benefits. So all the things that have listed here, those countries with strong technological capacity and advance and a strong scientific capacity, the convention or the treaty provides an opportunity for you to share data, for you to share information, for you to share resources among developing states. Therefore, it is important that Ghana as a country should get itself ready, especially our universities and what have you, should be getting ready to take advantage of the provision of the BBNJ. The last one, the marine genetic resources. So the convention that the BBNJ treaty also creates a system for a fair and equitable sharing of benefits arising from activities related to the marine genetic resources of the area, such as collection, access to the MGR stored in repositories, and utilization of the MGR and digital sequence information, DSI. So, now, for example, if when we had the COVID, AIDS is there, the SARS. Also, we are very fortunate that we don't have SARS. So tests used to do the diagnosis of COVID-19, AIDS, SARS, and other diseases were developed with the help of an enzyme isolated from bacteria found in the deep sea hydrothermal vents. You remember I talked about what the why of biodiversity for which we need to protect. Now, it's a clear example of this from a bacteria that is found in the deep sea, in the area called the hydrothermal vent, which was used to do the COVID-19 diagnosis and the other things that I have mentioned. So that is one. Then you also realize that here we are talking about benefit sharing. The benefit sharing is not only monetary, but non-monetary benefit sharing is also part of this provision. In that non-monetary will come in the form of capacity building, anything that will enhance the capacity of a developing state in order for them also to implement the convention is captured under here. Then in terms of the monetary benefit sharing paid by developed states, 50% off, and in addition to access contributions, options for the COP to determine that. So what I mean over there is that during the COP, these things are going to be taken seriously for negotiations. For now, yes, we identify a challenge in the UNCLOS 3, but this one also provides some little limitation. We don't have the definition of DSI. There is no clarity on the MGR, the DSA distinct, and the DSI. So there will be a need for the DSA to be distinct from one another over here. Then we don't have a language stating that the MGR are the common heritage of mankind, the marine genetic resources. There's no language in the text that makes reference to that it is the common heritage of mankind. Then ability to make recommendations on measures where measures are within competency of existing bodies. Then, of course, intellectual property rights protection in 3 separate articles. So those are the provisions. Now, as we draw closer, we want to look at the legal, policy, and institutional implications of what we're talking about. For Ghana, we have done the signature ratification. So we have to domesticate this into our national laws if we want to benefit from the implementation. We have to do some level of development or amendment to our national legislation where necessary, regulating activities in the areas beyond national jurisdiction, because we have one. In terms of, we need also to establish a legal procedure for the implementation of the EIA activities under the BBNJ. It must be in compliance with rules governing access to and benefit sharing from marine genetic resources. We have a lot of work to do. In terms of policy implication, we have to integrate the BBNJ commitment in our national ocean governance, our biodiversity, including the MBSAP, and then our marine and spatial planning policies. We need to begin to do that now. We also need to do a serious alignment with the global framework, such as the CBD, as I indicated earlier on. Then we also need to develop strategies for marine and sustainable use and participating in the high sea governance. In terms of institutional implication, I want to indicate that participation in new governance structures, such as the COP under the agreement, is very critical. We shouldn't just say, oh, okay, this is one of the multilateral agreements. So we just carry ourselves and then go there. Let me indicate here. Implementation of the BBNJ is science-based. So if Ghana will benefit, then we need to strengthen our scientific institutions and give that scientific capacity to both negotiators and then those who are going to formulate policies. We also need to have a strategy for engaging the scientific body, and then of course the clearinghouse mechanism, which is also established by the convention. Then try as much as possible to have some clear coordinated arrangement among national institutions responsible for marine research, environment affairs. That is very, very critical so that we can avoid institutional policy incoherence. Science, money, and technology transfer. Of course, I have talked about beneficiary, so just not to waste much time. Beneficiary needs to be especially considered the limited capacity of developing states to engage in exploration, bioprospecting, blah blah blah. All of these things that I spoke about, that is the bottom line. One thing that is also very important is freedom of the high seas principle, which is going to be applied as a standalone principle, will mean countries will exploit marine genetic resources on first come, first safe basis, resulting in the increased likelihood of global equities or inequality. What it means is that we play with and see attitude. By the time you get, other countries might have taken what might be benefits to you. Right. The last but not the least, all of these things that we are talking about, BBNJ, Ghana has initiated a process of establishing a Blue Economy Commission. We have gotten Ministry of Fisheries and Aquaculture Development. We have a Sustainable Ocean Plan. How do we put all of these things together to take advantage of provisions of the BBNJ agreement? So, as I indicated here, within the fisheries and aquaculture sector, we must do everything possible to protect migratory species and spawning grounds for sustainable yields. Marine biotechnology and pharmaceuticals, we must begin to have it to provide the relevant to our blue economy is that to provide access resources for innovation and industry. That's why I'm talking about scientific awareness. Then when it comes to shipping and ports, it will the compliance with high sea environmental standards strengthened and maritime trade will be enhanced. Then renewable ocean energy, it will support for offshore wind, tidal energy development. Again, here we are looking at investing and investment in the area of renewable ocean energy. Last but not the least, tourism and recreation. A healthy ecosystem enhances eco and marine tourism. It is important that we look at the implementation of the BBNJ through the of our fisheries and aquaculture, our marine biotechnology and pharmaceutical industry. There have been too many diseases and sicknesses, illnesses with now. If we can increase our research into this area, then of course findings from genetic resources will be available for us to maybe manufacturers or producers of some medicines for the health sector. Then of course energy is everything. Once we can tap into, we have the speed along the coast, the tidal, the waves, and then will support, will complement our existing quest for full 100% energy for the country. I have some key questions. So, to all of this, as Ghanaians or as whichever country you belong to, which institutions within your own countries or for specific Ghana here, are we going to anchor the implementation of the BBNJ? Because I believe some of you are policymakers, some of you are from the university and that. The next question I put is, what should Ghana's BBNJ implementation roadmap look like? Last but not the least, which universities should be partnering with well-endowed research institutions or universities for marine technology? Yeah, so these are rhetorical questions that you take home so that be thinking about it when you have the opportunity of sitting in any policy dialogue or policy meeting, then or your institutions have been invited for how to implement the BBNG, then you begin to provide some useful answers as you participate in this meeting. So on that score, I said thank you very much. Yeah, thank you very much, Alvin. That's a very important question. I know youth has a lot of energy, capacity, passion, and enthusiasm. The first point that I'll make is that youth should take their time to study the test, to understand the requirements or the implications within of the test. So once you are able to do that, then you can then structure your activities in the area of advocacy. And if you want to do advocacy, let your advocacy be science-based and data-driven. Don't just get up and say, oh, they say biodiversity beyond national jurisdiction. So you start talking. In order for the youth to become relevant in this process, their advocacy have to be science-based. They have to take time to understand the test. Research, gather knowledge, so that when you are making policy advocacy for how the convention or the treaty should be implemented, you will be speaking from an informed position based on science and evidence. I hope